May it please, my Lord, I appear on behalf of the appellant, Mr. Golding, with Mr. Walker, and my learned friend, Mr. Rainey QC, and Mr. Sadiq appear on behalf of the respondent. This is an appeal, a second appeal from a decision of His Honour Judge Luber QC in the County Court at Central London, finding for the respondent on her appeal on judgment that was given on the 2nd of March 2008.
Yes.
Permission was given by Lady Justice Asplin on the 23rd of July 2008.
18.
Sorry, 18.
I didn't think the backlog was that long.
Quite the opposite, according to the Master Roll.
My Lord, your Lordship should have before you the core skeleton bundle and also the supplementary bundle and a bundle of authorities.
Yes, correct. We do have
My Lord, have you had the opportunity of reading all of the skeleton arguments?
Yes, we've read the skeleton arguments, we've read the judgments. Indeed, now we are conscious that there are applications to raise new issues and to put in on one side and to put in some new evidence on your side. Is that right?
My Lord, we're no longer pursuing the need to put in new evidence.
Right. But I think in order for you to address us on the various points that are in issue, we need to understand whether the respondent is entitled to put in, to advance new points on the appeal.
Indeed, my Lord.
Would it be sensible to start with that issue?
Yes, my Lord.
There we are. Yeah, Mr. Raven.
Lord, the new points break down into two categories because they're in the respondent's notice, but grounds 1 and 2 are different from 3, 4 and 5. Grounds 1 and 2 are different because in my submission, if this court is in effect to perform the function which Lady Justice Asplin would have thought was the function on the second appeal, which is to decide an important point of general principle, then it ought to decide it on the correct basis. And my submission is that grounds 1 and 2 are inextricably linked with the ground of appeal. Because the ground of appeal is as to whether or not the prospect of obtaining relief from forfeiture under section 138(3) is a reasonable prospect of success at trial for the purposes of CPR 39.53C as applied by analogy under Hackney and Findlay. And the basis for that, the basis for the argument on that is what is the character of the application you make under section 138(3. And it's been answered in two different ways. Deputy District Judge Moerbia thought it wasn't within the meaning of a reasonable prospect of success, and Judge Luber found that it was. And one reason I would submit why it might be at least a little more difficult to answer that question than might at first blush appear is because the question is wrong. Because what should have happened, and this is ground 1, is that the order should have been in a completely different form. And there are two decisions of the Court of Appeal which make this very clear.
You say in effect that ground 1 is a jurisdiction.
It is, because that's what it says, and it certainly says very clearly in Spurgeon's Holmes and Gentles. It says the only correct form of order is the one which is prescribed by the mandatory terms of section 138(3, which is the governing act of Parliament, and that is the only correct order. Where I have to row back slightly is that in Spurgeon's Holmes and Gentles, the Court of Appeal said that any litigant was perfectly entitled to ignore an order which was in the wrong form, and I would have to accept that, in view of later authority, that's probably going a bit far.
Yes. What you say is you say that a person who's faced with an order in the incorrect form is entitled to apply as of right to have it set aside. Until it's set aside, it's effective. But you say as of right, you're entitled to have it set aside. We've got that point. That's ground 1. What's ground 2?
Could I ask Mr. Rainey, I'm sorry, I was fiddling around trying to find the best place where you got all your 5 grounds set. I know what they are, but is this somewhere where I can...
Yes.
I've got... Yeah. I've got your revised skeleton argument raising it, but is in the respondent's notice, probably.
Page 268.
Yeah, I'm grateful.
And 269.
Sorry. Yes, of course. Thank you very much. I had seen it, just I've forgotten where it was. Thank you.
And so, in answering the question as to whether or not effectively getting an order in the right form is success or not, one has to address why it is in the wrong form. Because, in a sense, Section 1383 is automatic. You don't make an application for relief under 1383. You're supposed to get it by law, and it wasn't given. And the Court of Appeal, as I said, in Croydon Unique, which builds on Spurgeon, Soames and Gentles, have said, well, if it's in the wrong form, you can go back, you get it in the right form, and the 4 weeks will start again. And there's the relief, there's the opportunity to pay. So for that reason, although it wasn't put in that way below, although it was referred to by Judge Luber realised, I think he called the order curious in his judgment, but it wasn't advanced that that was a separate ground, so I probably do need your permission. But it does go to jurisdiction, and I say it's quite different from Jones versus MBNA, which is, in any event, a trial case. It's different from the Schmidt case because I'm not asking you to do anything that the judge wasn't asked to do. I'm simply asking you to send it back to the deputy or to the district judge as the judge ordered. And third, if it's closest to anything, it's closest to Pitalis and Grant, where a fundamental point effectively going to jurisdiction, in that case under the Rent Act, was in effect wrongly conceded at trial, and the Court of Appeal said, well, it's a short point of law and it goes to the Rent Act protection, and they permitted counsel to take the point. So for those reasons, in my submission, to take ground 1. Ground 2 is slightly further away, I would accept, than ground 1, because the way I have framed ground 2, it's the difference between Forslux and Binney and Hackney and Findlay. I accept that it was specifically accepted below that Hackney and Findlay was the governing of the 2 Court of Appeal cases. I do nevertheless advance the point to your lordships that actually, if you look at the facts of it, this is a Forslux and Binney case, because it's forfeiture of a long lease for a relatively modest sum of service charge arrears. There is, on the basis of the findings, it was not known to my client that the forfeiture hearing was taking place. There are questions about service, etc. And so I would say it falls on the Forslux side of the line. If that were right, then one wouldn't, strictly speaking, need to go through the CPR 39.3 hoops, although no doubt your lordships would nevertheless not send it back if it was hopeless. I need that, in a sense, less than ground 1, because you could decide the case simply on the basis of Hackney and Findlay. But given that this is a forfeiture case, and given that this is a point of general importance as to how relief works in the context of applications to set aside the court order below, I would ask your lordships at least to consider the point as to whether this is on the Forslux and Binney side of the line.
Forslux and Binney considered whether there would be a successful defence, did it not?
It did.
And said that there would be.
Yes. So I have that anyway, in a sense, because that is a point which can be taken whether you're under 39.3 or whether you're in the more general realms of CPR 3.1. The difference is that if it's a Forslux and Binney case, then the application by analogy of CPR 39.3 doesn't take place, and therefore, in effect, the court takes a more relaxed view, putting it in very broad terms.
I suppose, anyway, you would say that it would look odd if, in this case, where the facts are analogous to Lady Justice Arden's case, that we didn't, if we don't adopt the same approach as she did, to explain why we're not.
Yes, or at least...
If I was a reader is concerned of the report, they'd say, well, that's very odd, why they're applying 39.35 rather than doing what was done in Forslux and Binney, and there's no explanation of that, and leaves, you would say, the reader in some confusion.
or perhaps worse, because it might suggest that Force Lux and Binny is in practice a bit of a dead letter, because this is not very far away. I mean, I accept that in Force Lux and Binny, I think it was less than £1,000, whereas here the sum is, I think, £12,000 odd. So you can say that there is a higher level of unpaid arrears, but if the worth of the lease is something in the hundreds of thousands, the exact figure is disputed, nevertheless it is disproportionate.
All right, we've got that point.
So those two reasons.
Right, what about all the others?
Grounds 3, 4 and 5 are simply additional grounds which I would submit that the court ought to take at least some notice of, because they would each be reasons as to why there would be a prospect of success were it to go back to the Deputy District Judge.
You said in your first numbers, I recall, that actually all these points could be left over if you were otherwise successful.
They would be.
It's fair.
Yes.
They would all be left over.
Yes.
And I mean, there is a point, isn't there, that, you know, frankly, that you're here on a second appeal on points of principle.
Yes.
None of these raise points of principle.
No, they don't. I see that point, and I've thought about it. There's, in a sense, either a lacuna or an oddity, in effect, about the rules. My client succeeded in front of Judge Luber, but for the argument that there's a point of principle, she could have reasonably expected that that was the end of it and it was going back to the district judge. The appellant is able to fit through the gateway for a second appeal, which is narrowly confined, and they are narrowly confined to their grounds. But having got through it, the consequence of losing is the same for my client, whether it's through a narrow gateway or a wide one. And so if there's a respondent's point available, then in my submission it's not confined by the same principles which confine second appeals. I would say I ought to be able to advance on behalf of my client any other basis for keeping hold of the decision in her favour. That would be my submission as to how that point works. But yes, to answer your previous question, they're all points which can be advanced before the Deputy District Judge or the District Judge when it is remitted.
And as far as ground 4 is concerned, non-service, the Deputy District Judge in effect says that it was inherent in the application under 39.3 that the judgment was a regular judgment in the sense that it had been served. So that point was not only not argued below, it seems to have been common ground below.
I would have to say that standing here, having come into the case at a late stage, it doesn't appear to have been argued perhaps in the way I would have argued it below. But yes, I can see the point that if you're applying under 3.1 and you're accepting that 39.3 applies, then there is a logical assumption that it's properly served, because Nelson and Clear Springs would suggest that if it's not served, you don't need to go through those hoops. I do accept that. Nevertheless, in my submission, it's quite a powerful case that it wasn't properly served. It's it's a singular set of circumstances when they have, in fact, by the time it's served, the locks have been changed. The only person with keys is the appellant.
We know the facts.
But yeah, I can't deny that it was ventilated below. I think the way it was put was that the service point went to discretion, which no, my lord, as I say, 3, 4 and 5 are points which I could advance below, but in my submission it was, I would nevertheless, because of course I don't know what the result may be on the others, I wouldn't drop the points, and I would ask that those points, that I am allowed to run those points, but I don't need to run them if my client is successful in resisting the appeal on the other grounds.
Thank you very much. Yes, now, Mr. Sinnott.
My Lord, yes. Turning first to the question of nullity. My Lord will see in the supplementary skeleton argument that we argue that in fact it's not a nullity, but of course that only arises if the point is allowed in. The main argument against it is of course whether there has been prejudice by the point not being raised.
Yes.
The point could have been raised in the original application for set-aside. It wasn't raised at that time, and as a result, though there had already been the creation of a new lease, that lease was then sold on before the hearing itself. So putting it further aside. Also, in this case, as my learned friend has rightly conceded, a party is entitled, until it's set aside, to rely upon an order as being an effective order. So in going in pursuant to that order, that was perfectly within the rights of the appellant. And as a result, they have now suffered that prejudice of having relied upon an order which they now seek to have set aside.
But it was always known that there was going to be a challenge to the forfeiture.
My lord, no, it wasn't always known that there would be a challenge. The challenge came very, very late in the day. It came very close, given that the re-entry was in August and the challenge set aside was in January of the following year. It was only, if they decided there to make an application for relief under section 1389A, they would have been in time. But then...
So the grant of the new lease is within the period in which the landlord ought to have known that it was open to the lessee to apply for relief against forfeiture.
Look, the landlord was aware that was a possibility. There's no contention to that.
Once he granted the lease, it was out of his hands whether that lease was sold on or not.
Indeed, but in this instance, he was relying upon the enforceability of an order of the court.
Yes, but the order was, so to speak, conditionally enforceable because there was still a 6-month window within which the lessee was entitled to apply for relief, assuming that the order had been in the proper form.
But within that 6-month window, the application would have been made under section 1389A, and the order for relief would have been discretionary, and one of the factors they would have taken into account was that, in fact, a new lease had been created. Now, the landlord takes a risk that may be...
It wouldn't have been a very forceful point, though, the prejudice at that stage. I mean, the risk was taken, as my lord has just put to you.
It is not as forceful as other instances, I would concede that, but it is still an instance of what, given that the courts have said very clearly that you can rely upon an order, even if it's in an incorrect form, and you may enforce that order. So he's then relied upon that in the knowledge that section 1389A means that there could be an application for relief from forfeiture, but that it would be taken into account in that application for relief from forfeiture that he had granted a new lease and acted to his detriment. The question here isn't the case that an order in the incorrect form is a nullity and therefore automatically gets set aside. It still has to be set aside by order of the court. And in my submission, it's for the court to consider all the surrounding circumstances. One of those being that this, in effect, cannot now be unpicked because we have an innocent third party who has a lease of the property, and that situation has now gone on for a number of years without being set aside by the court. There is also the additional point as to purpose, and this goes to my learned friend's ground in terms of the Nelson Yard and the service point. And following the decision of this court in Gibbs, it is now established in that case that where you had a situation where because of service no order should ever be made, but a landlord effected re-entry, that was deemed, because there was no service, there had been no forfeiture, so that re-entry took effect as peaceable re-entry, and that would have triggered section 1389A. Now, in citing the Croydon case, my learned friend relies upon the dicta that if you rely upon the rules, then you can't use the rules to defend yourself, but that cuts both ways. If the court were to find that this was a nullity, then in effect it would be open for the landlord, in the case of a nullity and in the Croydon case, it didn't say that the landlord would have to go back for another order of the court. It was that they may go back for an order of the court. It would be open to the landlord, to the appellant, to accept the service point and say, yes, it wasn't properly served, therefore forfeiture was not affected by service, and we rely upon Gibbs because we went back in August by the granting of a new lease. We'd already changed the locks, we had physical possession of the property. We rely upon Gibbs that forfeiture was affected, and an application for forfeiture should have been made under section 139 for relief within the 6-month period, and just like with Gibbs, that time has now well passed. So it would become, in my submission, a purely academic exercise to say that the order was a nullity, set it aside, and proceed on that basis. And the irony of this is that there's a slight incentive that, in some respects, based upon the authority of Gibbs, it would actually be in the appellant's interests to say that the case was a nullity and have it set aside and accept the service point and say, well, your time is over.
Anything else on the first ground?
No, nothing further on the first ground. In terms of the Forsloo and Binney point, it's not just that it was conceded, it's quite clear that it was common ground that this was a Finlay case. And first of all, Finlay does distinguish, in my submission, Forsloo in saying that those were highly unusual circumstances of that case. It also deals with two different scenarios. And my learned friend says that this case is on all fours with Forsloo, but it's not, because in Forsloo, possession had not actually been retaken, and also the sums of money involved were very, very different. And in Forsloo, they weren't talking about the automatic granting of relief from forfeiture that one achieves under section 1383 if an order is made in that form. So this is far more a case akin to the Findlay scenario rather than the Forsloo scenario.
Well, that's the argument on the substantive merits of the point, rather than whether Mr. Rainey should be allowed to raise it at all. Unless you're saying his point is so unarguable that we shouldn't allow it to be raised on that ground. There are two distinct questions. Should he be allowed to argue it? And if he is allowed to argue it, is it right? And you've addressed the second question, but not the first.
Well, I think on the first one you say it was common ground.
I do.
And that's your only point.
Yes.
Your only point. And I think that's accepted, that the point wasn't taken below. So the only question is, should that point be allowed to be taken here, bearing in mind that however we decide this case, we're going to have to comment on the relationship between Hackney, the Findlay case and other cases, aren't we?
Indeed,
We're
my
going to
lord.
say why this falls within one side of the line or the other anyway. So you'll be able to advance all the reasons.
I accept that, my lord, and I accept that my argument on the second point is not as on the second ground is not as strong as the nullity argument.
All right. What about then 3, 4, and 5? What do you say about that?
My lord, in my submission, all of those points require the consideration of further evidence. The evidence that was filed in terms of entry was not filed to address the question of waiver, and also it didn't address the question of communication of that waiver. Similarly, in terms of service, bold assertions have been made as to the investigations that were made and whether a further step should be taken, and there's been no opportunity to address that with further evidence.
Yes.
And my lord, that was part of the reason why originally we were wanting to submit evidence and then we've taken the view that actually the point is simply made by the fact that it would require further evidence. That this court does not, in my submission, need to read what further evidence that would be. The point is clear.
Yes. All right. Anything else?
No, my lord.
We'll rise for a few minutes to decide how we do this.
All right.